Thanks to CuriosityStream for keeping Legal Eagle in the air, which now comes with Nebula for free when you use the link in the description. Well, the president has now gone to war with Twitter because Twitter is applying warning labels to some of his tweets. It's 2020, so that pretty much checks out. As you may know, President Trump is a fierce critic of speech that disagrees with his own viewpoints, and don't take my word for it, take his.
See, I don't think that the mainstream media is free speech either, because it's so crooked, it's so dishonest. So to me, free speech is not when you see something good and then you purposely write bad. To me, that's very dangerous speech.
But as president, he believes that he has the power to shut down private companies who distribute comments that he doesn't like. He tweeted, "Republicans feel that social media platforms totally silence conservative voices. We will strongly regulate or close them down before we can ever allow this to happen." And President Trump has toyed with issuing an executive order targeting online tech companies for years. But now that Twitter has started putting warnings on some tweets that the president tweets out, the dam appears to have finally broken. The American president issued an executive order purporting to dictate how online platforms like Twitter, Facebook, and Instagram regulate speech online, which of course brings up the age-old debate between platforms and publishers, the Communications Decency Act, Section 230, and the First Amendment. So the question is, what did the president just do, and can he do it? And does he understand the First Amendment? Hey, LegalEagles, it's time to think like a lawyer because there may not be a single topic more misunderstood than freedom of speech. So let's start at the beginning. The first one, the First Amendment. As you may know, the First Amendment protects freedom of speech, among other things. Now, the biggest misconception about freedom of speech via the First Amendment is that it restricts what the government can do to private individuals. The key phrase in the First Amendment text is that Congress shall make no law. This means that the First Amendment is directed at stopping the government from censoring speech or compelling speech. Private companies, generally speaking, can do whatever they want as it regards speech. Now, of course, there are exceptions to this, carved out by the Supreme Court for some limited categories of obscenity and creating imminent lawless action, but these are the tiny exceptions to the general rule that the First Amendment prohibits the government from restricting private individuals or private companies' speech. And the term freedom of speech has a specific legal meaning. Freedom of speech is a negative right against the government that prevents the government from punishing most kinds of speech. Freedom of speech does not apply to private companies, generally speaking. And also, generally speaking, it prevents the government from forcing individuals to make speech. That is called compelled speech. So, as a general rule, as one commentator put it, the Constitution protects Twitter from the policing of a president. It does not protect a president from the policing of Twitter. And similarly, that gets into censorship, which is a different side of the same coin. Censorship is when the government restricts or prohibits certain kinds of speech. It's a governmental action. Private companies might delete comments or moderate content, and you might think that that's a bad thing, and you might have great arguments for that, but whatever that is, it's not censorship, at least not in the legal sense. Nor is censorship facing the repercussions of one's own speech. The First Amendment and freedom of speech doesn't shield you from the social consequences of the speech that you made. So with that very general background about the First Amendment and freedom of speech, that takes us to the Communications Decency Act. Now, you might have heard of the terms platform or publisher before. Generally, that comes from a certain section of the Communications Decency Act, Section 230. So if you've ever heard someone refer to 230 or Section 230, what they're probably talking about is the Communications Decency Act, including the president who just recently tweeted out that we should revoke 230 without providing any context. Now, if you've ever read the First Amendment, you might notice that it says nothing about platforms or publishers or responsibility for defamation. That's because it relates to the CDA, which was passed in 1996. Now, we'll talk about what the CDA Section 230 does in just a second, but I think it's worth going over the history of the Communications Decency Act, because the history that led to the founding of this particular law is incredibly fascinating, and it harkens back to the very beginnings of the internet. Now, in the early days of the internet, there were no laws regulating the content on the internet, and it quickly became apparent that if people posted whatever they felt like saying, some inappropriate and illegal things could make their way onto the web. Someone could post child pornography. Some people could post incredibly defamatory statements, and not to mention people posting things that just violate someone's copyright. And lawyers and legislatures had to grapple with whether there would be liability attached not only to the person that posted that information, but anyone who hosted that information. Now, traditionally, content distributors were not liable if they distributed something that ran afoul of one of the areas where speech is restricted or has legal liability. And I'm using the term content distributors incredibly loosely. Here, we're talking about historically stores and newspapers. Now, in the 1950s, the Supreme Court overturned a Los Angeles ordinance that said if you have obscene material in your store, you can be held criminally responsible for selling that paraphernalia. In particular, a bookstore owner was convicted of violating the ordinance by selling a novel called Sweeter Than Life, which tells the story of a, quote, ruthless lesbian businesswoman. The store owner was sentenced to 30 days in jail for simply selling the book. The Supreme Court said that the bookstore couldn't be responsible for reviewing every single thing that was in the book or magazine that it happens to sell. Fast forward about 40 years with the invention of the internet, we now have a similar but different situation involving ISPs and people that host content on their websites. Now, two of the first ISPs, CompuServe and Prodigy, were both sued for hosting forums where users posted defamatory content. Prodigy, for example, billed itself out as a family-friendly ISP, so it moderated comments that were hosted in its forums, removing things that it thought were bad. Now, CompuServe, on the other hand, didn't moderate anything in its forums, and as a result, the courts found that this distinction was important. But both CompuServe and Prodigy were sued for the allegedly defamatory content that was posted in their respective forums. Now, the case against CompuServe was dismissed because the court considered that CompuServe was merely a content hoster and a distributor rather than an author or a publisher. As a distributor, CompuServe could only be held liable for defamation if it knew or had reason to know of the defamatory nature of the content. But since CompuServe wasn't moderating its forums, it had no reason to know what material was posted to those forums. But things turned out differently for Prodigy, the company that wanted to be family-friendly. A post appeared on a Money Talk forum claiming that the investment firm Stratton Oakmont committed criminal fraud in connection with a stock IPO. Yes, that Stratton Oakmont, the one that gave rise to the film Wolf of Wall Street.
Gentlemen, welcome to Stratton Oakmont.
I can't imagine why someone thought that Stratton Oakmont was committing fraud. But the firm Stratton Oakmont sued not only the anonymous poster who posted the allegedly defamatory content that, in retrospect, was probably not defamatory in any way, but it also sued Prodigy for hosting that content. And a court held that Prodigy was liable as the publisher of the content created by its users since it exercised editorial control over the messages on its bulletin board. And unlike CompuServe, which was compared to a bookstore, Prodigy was considered to be more like the editor of a newspaper's opinion page. In essence, Prodigy was liable because they created content guidelines, proactively enforced those guidelines, and used software designed to remove offensive language. And under this reasoning, Prodigy knew or had reason to know that the content was quote-unquote defamatory since they had those guidelines in place and were exercising their discretion. Now, it's worth noting that these weren't Supreme Court cases. These outcomes aren't necessarily dictated by the Constitution. These are lower court opinions about the interaction between ISPs and defamation. So these cases aren't necessarily set in stone, but early internet companies drew a very clear lesson from these lawsuits. They shouldn't do any moderation at all since that was the best way to avoid liability. There didn't appear to be a middle ground between absolute lawlessness and some kind of moderation. But before any of these cases could go to the Supreme Court, Congress actually stepped in. Congress didn't like the fact that businesses were being held liable for the acts of their users. When Congress finally enacted the Communications Decency Act, they were doing that in response to the moderation dilemma. Lawmakers wanted online service providers to be able to moderate content. At the time, they were especially worried about things like harassment and obscene material. So they gave online providers immunity from lawsuits if they moderated their content. And as an incentive for internet companies to create basic standards, the law granted them immunity from liability if they simply adopted standards and enforced them. The Communications Decency Act was specifically created so websites didn't need to be neutral. So that takes us to the controversial Section 230. The relevant portion of the CDA Section 230 is actually very short, clear, well-worded, and an understandable piece of law. If you go to Section 230 subsection C, it's called Protection for Good Samaritan Blocking and Screening of Offensive Material. Sub 1 says, treatment of publisher or speaker. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And the term another information content provider is incredibly important. That means another user, a commenter, a tweeter, a person on Facebook, a person posting to Instagram. So that's the general immunity that protects not only Twitter, but someone that happens to have a YouTube channel or a blog from being liable for the postings of other users and content providers. But then subsection 2 goes a little bit further, and it specifically allows for people to moderate content on their platforms or websites. It states that no provider or user of an interactive computer service shall be held liable on account of A, any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected or not, or B, any action taken to enable or make available to information content providers or others the technical means to restrict access to material described in paragraph 1. So let's talk about these two provisions. Section 230C1 establishes the immunity for third-party liability, under which a website is not to be treated as the speaker or, let's say, publisher of the illegal or otherwise offensive content posted on a website by a third-party end user, or what the CDA refers to as another information content provider. We'll summarize that as you're not responsible for what a different user posts to your site. Now, Section C2 also protects websites against any civil liability should sites engage in self-regulation or make good faith efforts to edit the website by blocking, screening, or restricting access to basically any content that they don't want on their website. So in other words, platforms like Twitter or Facebook or blogs or YouTube channels can't be sued for defamation on the basis that they had knowledge of defamatory or otherwise illegal content on the basis that they moderated their content and were going through comments or other postings and removing ones that they didn't like and didn't want on their website. And it's hard to overstate the importance of Section 230 in the development of the early internet, and really as the internet has developed to this day. Whether you agree with it or not, it is a powerful tool that provides immunity and shields internet service providers and websites from liability for content that they host. And we'll certainly get into the differing opinions on whether 230 is a good thing or a bad thing. But as a legal matter, decades of court decisions have affirmed the robust immunity that is provided under the CDA Section 230. And here are a few recent examples that show how Section 230 has been used as a shield by content providers. For example, a man sued the Grindr dating app for negligence, products liability, and related claims after someone impersonated him and posted fake profiles on the app. The court found that Section 230 barred claims against Grindr for the design of its platform as within the purview of protected traditional editorial functions. Similarly, in Wisconsin, a plaintiff sued a classified advertising website because the plaintiff wound up buying what turned out to be a murder weapon from a private seller. The case was dismissed because the plaintiff sued the website, claiming that the website was responsible for what someone else had posted to the website and ultimately sold to that person. But the website didn't sell the gun, it just hosted the ad for it. So it wasn't responsible for what happened to go wrong with that sale. But here's a key point that's often misunderstood. In both of those cases, the person that wrote the posts that ultimately was misleading or illegal, they're responsible for the legal repercussions of those posts. Just like anyone that posts defamatory content on Twitter is responsible for the defamation that they may have done. The only thing that the CDA Section 230 does is it exempts the platform or the website from being legally responsible for the posting of some other third-party content user. But by the same token, websites and platforms want the flexibility to be able to remove those kinds of postings if they so choose. If they find out that someone is trying to sell a murder weapon in a classified ad, they want the flexibility to be able to remove that post if they find out about it. So if you've ever wondered why websites have these incredibly long terms of service contracts that effectively allow websites to do whatever they want and remove whatever content or users they want to, that's why. But obviously Section 230 has received criticism on both the left and the right. There are many people who claim that Section 230 discriminates against certain kinds of viewpoints, in particular political viewpoints. And ironically, my Twitter feed is full of people on the left who claim that tech companies are biased against their views, and people on the right who claim that tech companies are biased against their views as well. Certainly, it's not surprising that when websites moderate their content and their users, that people are going to claim viewpoint and political viewpoint discrimination. But as a practical matter, the vast majority of people probably don't want true neutral platforms. It's a place of anarchy that's ruled by extremists and the hecklers. There's this concept in First Amendment law called the heckler's veto, where, for example, you're not allowed to discriminate against a speaker coming to, let's say, a public forum based on the reaction of the people that are going to view that speech. So, for example, if there was going to be a speaker at a college campus and you knew that the college kids were going to riot or create violence in response to this particular speaker, if you allowed that violence to dictate who can and cannot come to the college campus, the hecklers are allowed to veto any kinds of speakers. And so that's not a valid basis to discriminate against someone's viewpoint in a public forum. That, again, has nothing to do with a private forum. But you can imagine that there's an analogy there to where if you're not allowed to do content moderation, that it's the extremist and the loudest voices that are going to rule all of these different platforms. Now, there's a time and a place for a 4chan or an 8chan. I just don't want to hang out there, and I don't think most people do either. And the ultimate irony is that if Section 230 didn't exist or it was revoked, and Twitter was liable for anything that its users posted, as a result, they 100% would delete Donald Trump's account and would not allow him to post, or they would vet all of his tweets before allowing them to go public. And we focus on the big tech companies, but it goes far, far deeper than that. It's every YouTube channel, every blog, any website that hosts comments. I asked my fellow internet lawyer Richard Hoeg to talk about what would happen if Section 230 were revoked or severely curtailed.
Hey Legal Eagle, it's Rick from HoegLaw. You might remember me from such YouTube videos as Kappa, I Just Can't Quit You, Kappa, It's Not You, It's Me, and other things. As you rightly point out, CDA Section 230 is a foundational piece of the internet superstructure, and as a foundational piece, it's important not just to the Apple, Facebooks, and Googles of the world, but also to places like Reset Era, if you're interested in talking about video games, or Reddit, if you're interested in talking about video games. The language of Section 230 makes no distinction between large operators and small, which means it protects everyone, but also that a change in that law will affect everyone. And not to put too fine a point on it, but the FTC most recently, while discussing COPPA, has intimated that YouTube channel runners like you or me are responsible for the content that appears on those channels as if they were YouTube itself. So what does removal of Section 230 mean? It means that places like Reddit or your channel or mine might have to be responsible for every comment that appears on them. You might have to be responsible for the comments that appear on your YouTube videos. I don't want that. I know you don't either. Now, I'm not trying to pretend that Section 230 or DMCA or COPPA descended from divine writ and that we need to hold fast to every bit of the language that was offered. But I do think that we need to be very cautious about any law that affects this many people.
I think Richard's right. The stakes are incredibly high, and revoking 230 could destroy the internet as we know it. Definitely check out Richard's YouTube channel that has great analysis about internet and entertainment law. So that's the basics about the Communications Decency Act, but misunderstandings about Section 230 abound on the internet. So let's take some time to dispel some of those misunderstandings. The first is, of course, what about publishers and platforms? Journalists, politicians, and internet commentators frequently make a mistake when they talk about CDA Section 230 immunity. They often say that these internet companies or websites either are publishers and are responsible for the content that their users post, or that they should be treated like publishers and held responsible for what their users post, regardless of what the law currently is constituted. But that's not really the key distinction. Websites are already liable for the content that they create. A website like Twitter or Facebook or a newspaper like the New York Times can and often does create content. And when they do that, they are responsible for the legal repercussions of the content that they create. A website can be both a publisher, an author, and a platform at the same time. As the law stands, they just aren't responsible for the content of the users or other third parties that post to those websites or platforms, nor are they liable if they choose to moderate their users' content. The law currently recognizes that some internet providers share some similarities to edited print publications like newspapers in certain contexts, which are, under some circumstances, held liable for third-party content. However, they also have attributes of common carriers like telephone companies, which serve as passive distributors of third-party information. Under Section 230, websites are held responsible for the content that they create themselves, but not for the content of other people that's simply posted. So this division between publisher, platform, or distributor is kind of a red herring. And the terms platform and publisher get very, very confused. Really, when you think of this distinction, you should think of it as the distinction between a host and an author. Hosts aren't liable for other users' content, but authors are always responsible for the content that they author. Sometimes a website can be an author, and sometimes a website can host other people's content. And sometimes a website can do both at the same time. You have to look at the particular speech in question to determine what applies in which context. And there are two other concepts that are continually made part of this debate that sort of get lumped into it. One is neutrality and the other is the fairness doctrine. Now, neutrality can mean different things in different contexts, but in this context, Senator Josh Hawley has introduced legislation that would amend the CDA Section 230 so that internet companies would lose their Section 230 immunity if they did not apply their rules in a politically neutral manner. This is obviously a response to the perceived anti-right-wing bias of certain tech companies. This is one of many amendments that are on the table that haven't passed, but potentially could in the future. Query whether this sort of viewpoint discrimination, in other words, not allowing viewpoint discrimination, passes First Amendment muster, because the government generally can't mandate that certain viewpoints be allowed or disallowed. The First Amendment has been around for a long time, and the Communications Decency Act has been around since 1996. So to take this action to change it is anti-conservative because you're changing the status quo. But that's a question for another time. Now, the related concept of the fairness doctrine harkens back to the days of broadcast media like radio and TV, which once had a legal duty to air balanced content covering both sides of a politically controversial issue. This was called the fairness doctrine. The idea was that because you were using the broadcast spectrum, of which there was only a limited supply, the broadcast networks had a duty to present both sides. Now, Republicans fought for years against the fairness doctrine because they argued that the balance requirement had a chilling effect on the delivery of the conservative message. And finally, in 1987, President Reagan repealed the fairness doctrine. This was considered a huge victory for freedom of speech because broadcast networks were no longer mandated to carry certain messages, and it actually led to the flourishing of things like conservative talk radio, since stations were free to broadcast views without offering other sides of the story. And while the original fairness doctrine only applied to broadcast media, those generally on the right who are detractors of the current makeup of the Communications Decency Act want to basically instill a new fairness doctrine onto the public platforms that host users' content. So with that context, that brings us to the war between President Trump and Twitter's Jack Dorsey. During the last few weeks, the president has gotten into several Twitter wars, first calling MSNBC's Joe Scarborough a murderer of a former staff member, prompting both Scarborough and the family of the deceased to speak out against Trump's comments.
Vile people driven by hatred and petty politics.
Though, ironically, since Trump's comments could get him sued for defamation when he leaves office, Twitter probably would not be responsible because they're immune under the Communications Decency Act. Second, the president has been bashing states that are promoting voting by mail during a pandemic. And as part of this feud, the president has made some wild statements about predictions of voter fraud that would come as a result of voting by mail, which are most likely false. Now, after considerable public pressure, Twitter decided not to moderate the tweets about the alleged murder, but did add some context to the tweets about voter fraud. And then recently, President Trump spent some time rage tweeting about racial tensions in the US, threatening to sic the military on protesters and effectively threatening to shoot looters. Twitter labeled those tweets as promoting violence and added a warning gate that you had to go through before you could actually view the president's tweet. And however you may feel about the president's underlying tweets or Twitter's response, it's more or less Twitter's decision to make. And I would argue that the language of the labels that they added to these tweets would constitute something that was authored by Twitter. So the language of the labels that were applied If, for example, those are defamatory, which I don't think people are arguing, but if they were, then Twitter would be liable for a defamatory statement because Twitter did in fact author those particular tweets. But that's a statement by Twitter itself as opposed to the statement of a third party. But regardless, this action by Twitter pushed President Trump over the edge, leading to the long-threatened executive order against social media platforms that he doesn't agree with. So let's look at the executive order of the president. Now, remember, an executive order can't change the law. Now, sometimes an executive order can be very powerful because the president is in control of the entire executive branch, which includes the military and the entire administrative state. But where Congress has written something into law, a presidential executive order cannot change what Congress has done. But that hasn't stopped the president from trying. And this particular executive order goes straight at Section 230 of the Communications Decency Act. The executive order starts by making policy arguments about what it's trying to accomplish and makes some statements about freedom of speech in the First Amendment. And remember when we started this video that this largely is not a free speech issue. This is speech that comes from a private party. Freedom of speech relates to a negative right against the government. So for the most part, makes the classic mistake of talking about freedom of speech when we're talking about the speech of private individuals. Now, the executive order goes on to attack the good faith requirement of the moderation of websites and says that because effectively websites are making viewpoint discriminations related to political ideals, that they're not operating in good faith. Now, that is the president's opinion about what the law says, an interpretation of good faith. That is not how courts have interpreted that requirement, and that's not how courts have made requirements for websites that actually moderate their particular comments. So this executive order does not carry the effect of law with respect to what courts are going to assume about Section 230 of the Communications Decency Act. And it's possible that Congress could change that requirement and adopt the Hawley Amendment, but at the moment they haven't, so this portion of the executive order doesn't really accomplish anything. But the order does go on to say that all federal agencies should adopt the president's understanding of this requirement and effectively curtail Section 230. And it asks the Department of Commerce and the FCC to adopt rulemaking to effectuate that decision. The FCC is supposed to be an independent regulatory body, so it's not clear whether they will adopt this or not. And generally, the FCC has said it actually doesn't have the power to police the internet in this way. So we'll see what happens with respect to that. The executive order also asked the FTC to consider website moderation an unfair trade practice, which might result in some action, but I have to believe that if the FTC punished websites for viewpoint discrimination, they'd run headlong into a bunch of First Amendment lawsuits. So not clear how strong that action would be. It also purports to create a mechanism for public complaints about violations of neutrality and moderation, and asks for a working group related to state attorneys general to be able to use state laws to prevent this kind of moderation. Though traditionally the Communications Decency Act has been ruled to preempt state laws as well, so it's not clear what, if any, the state AGs can do in this particular context. Now, interestingly, the executive order also relies on a legal theory that internet platforms are the functional modern equivalent of a public forum, and therefore it's everyone's right to be able to access that public forum. The theory is that the importance of social media in public discourse means that social media sites should be treated as government actors subject to the First Amendment rather than as private entities. And if websites were treated as state actors, then they would need to follow the First Amendment just as the government does, and just like the government, they couldn't ban, block, or delete content based on the viewpoint of that particular content. This, of course, is the antithesis of Section 230, which encouraged private companies to moderate content rather than let the internet collapse into anarchy. But at the heart of this debate is whether websites like Twitter or Facebook are the functional equivalent of a town square, or whether they're like a private house. Now, a town square generally has been a physical location that generally was a public good, publicly owned, and thus you couldn't restrict people from being able to access it. Whereas a private house, when you own that house, you can restrict as much speech as you want. So it's a question of that. And there are some cases that in very, very limited contexts have applied the sort of town square analogy to private places. For example, certain malls and company towns that were more like a traditional physical public location have, under some circumstances, had those restrictions applied to them. But in the vast majority of cases where you have a private company or a private individual, whether it's a restaurant or a commercial building or your own private house, you're not bound by the First Amendment, and you can restrict or promote whatever speech you want within the confines of your own private property. And sometimes those lines get blurred. There are no easy questions in law. So for example, when a government entity rents a hall for a public forum, they can't engage in viewpoint discrimination, even though it's private property, but it's sort of been commandeered by the government. Or when a governmental official uses Twitter as the official mouthpiece of that government agency. There have been a few cases that have said you're more like a government than a private entity in this particular limited channel or username. But it's certainly been interesting to see not only Twitter's response to the president's tweets, but the president's response to Twitter's response.
The choices that Twitter makes when it chooses to suppress, edit, blacklist, shadow, ban, are editorial decisions, pure and simple. They're editorial decisions.
After having some of his tweets be warning gated, the president apparently backed down a little bit and reversed course on some of the statements that he was making. And lost in this whole shuffle is that Twitter actually has a First Amendment right to express its opinion about what Trump is expressing in his tweets. Now, like any individual or company or person, Twitter will be responsible for the content that they actually author. But it is, of course, related to this larger context about content moderation on websites and platforms, and when a website is responsible for that content and not. And there are certainly advantages and disadvantages to having Section 230 on the books. It is largely responsible for how the internet looks today, whether you like that or not. And while it's probably a bad idea to repeal Section 230 entirely, what we really need is a law that prevents YouTubers who give great legal analysis from getting demonetized when they talk about sensitive subjects. But since that probably isn't going to happen, my creator friends and I teamed up to build our own platform where creators don't need to worry about demonetization or the dreaded algorithm. It's called Nebula, and we're thrilled to be partnering with CuriosityStream. Nebula is a place where creators can do what they do best: create. It's a place where we can both house our content ad-free and also experiment with original content in new series that probably wouldn't work on YouTube. In fact, if you liked this episode, the version that I put on Nebula removes this ad entirely and replaces it with an extended discussion about the First Amendment and Section 230. Forcing websites to take a speech-related action, and that, by its very definition, is anti-free speech. You'll get a whole extended rant that I'm not going to put on YouTube, and it's ad-free. And Nebula features lots of YouTube's top educational-ish creators like Thomas Frank, Lindsay Ellis, and Tirzu. We also get to collaborate in ways that probably wouldn't work on YouTube, like Tom Scott's amazing game show Money, where he puts a bunch of famous YouTubers against each other in psychological experiments where they can either work together or profit individually. It's amazing. It's wonderful. So what does this have to do with CuriosityStream? Well, as your go-to source for the best documentaries on the internet, they love educational content and educational creators. And we worked out a deal where if you sign up for CuriosityStream with a link in the description, not only will you get CuriosityStream, but you'll also get Nebula for free. And to be clear, that Nebula subscription is not a trial. It's free for as long as you're a CuriosityStream member. And for a limited time, for less than $20 per year or $3 per month, you can get CuriosityStream and Nebula together. And since we're spending a lot of time inside these days, you might as well do it with David Attenborough or Chris Hadfield, or just watch Tom Scott torture your favorite YouTubers. that's fine too. So if you click on the link in the description, you'll get both CuriosityStream and Nebula for a ridiculously low price. Or you can go to curiositystream.com/LegalEagle. It's a great way to support this channel and educational content directly for just $19 per year. So just click on the link in the description or go to curiositystream.com/LegalEagle. Clicking on that link really helps out this channel, and I really appreciate it. So do you agree with my analysis? Should Section 230 still exist, or should we repeal or amend it? Leave your objections in the comments and check out this playlist over here with all of my other real law reviews about pending legal issues on the internet and otherwise. So just click on this video and I'll see you in court.